if you have that card, you can only use what they give you and the amounts that they give you. Right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. Good morning. Are you Jonte Harmon? And this is your initial appearance. Ms. Harmon, in cause number 26, DCCR 0765, you're charged with the second-degree felony offense of burglary of a habitation. And that is from February 6th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so are you working? Okay, so what I'm going to do, Ms. Harmon, is reset your case for about 30 days or so to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get here to that attorney and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. You understand?
Yes.
All right, if you step in front of the clerk, she'll give you a reset notice. You're Michaela Sylvester?
Yes.
And Ms. Sylvester, this is your initial appearance in cause number 26, DCCR 0766. You're charged with the second-degree felony offense of burglary of a habitation from February 6th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
All right, so I'm going to do Ms. Sylvester's reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order. You would go back to jail. Do you understand?
Yes.
So you and Jonte are co-defendants, right? All right. I just printed something. Y'all both hang on just a second. I want to take a look at something, and then I'm gonna give y'all some rules. Did y'all come here today together?
Yes.
Ms. Harmon, come back up.
Yeah.
Together?
Yes.
Where do y'all live?
Well, we was at Autumn Oak, but they moved out of there like a couple of days ago. So we're going to be at this motel on College Street 2 weeks from now.
How old are y'all? How old are you?
18.
18?
18.
So first thing, condition of both of your bonds, if it's not already a condition, is that you guys aren't to be anywhere near the Autumn Oaks apartment. Y'all cannot go anywhere around there. Do you understand?
Yeah.
You also cannot have any contact or communication with Kraysha Young or Tyrone Harmon, who I know is your brother.
My dad.
Your dad. And who's Kraysha Young?
My stepsister.
Your stepsister. And they're the one, they live over there at Autumn Oaks.
Yes, ma'am.
So y'all need to stay away from both of them for now.
Okay.
Don't talk to them. Don't have anything to do with them. Don't have communication with your dad right now or anything like that. Do you understand?
Yes, ma'am.
Okay. Usually I order that you, if there's co-defendants, that y'all not have any contact or communication. Do y'all have anybody else to help y'all financially do anything? Okay. So I'm not going to order that, but obviously y'all need to stay away from that situation. If anything else comes up while you're out on bond where you two aren't getting along and there's some other issue and the cops are called out or you're kicked out of a hotel, then can have no contact or communication with each other. Do you understand that as well?
Yes.
Okay, so whatever's going on, y'all are in felony court now. Y'all are young. You need to grow up, make good decisions, so that you can get your cases taken care of and not be back here in trouble and or in custody.
Yeah.
Okay, all right. Did you get your reset notice? Step over here and get your reset notice, then y'all can leave. You're Terrence Currington?
Good.
And so, Mr. Currington, you've been here before and in this court because you entered a plea, so you should have known where you were going, right?
Yes.
Okay. All right, Mr. Currington was previously in court and cause number 25 DCCR 1114, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Chief.
Any additions or corrections?
Not from the defense.
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, then at the end, the case will actually be dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for up to 10 years. Do you understand? So it's my understanding that you have a THC card through the Texas Compassionate Use Program. Is that correct? Okay, so here's the thing. If you have that card, you can only use what they give you and the amounts that they give you. Right? So when you were caught here, you had a whole lot more of stuff that you weren't supposed to have. 2.6 ounces.
That's not good.
They didn't charge you with it, but they found some.
Inventory of the vehicle revealed a black backpack in the front seat containing 2 clear plastic bags of suspected marijuana totaling 2.605 ounces. That's not compassionate care stuff, is it? It is. That's how they give it to you in little plastic baggies.
No, that's you see.
She's asking for stuff that.
I'm asking you.
Is that?
What? Here's the thing. I'm sorry.
He's in the bag. Plastic bag.
Is that how they give it to you?
Oh man.
Okay.
You just put it in there
Why would you do that?
for the smell.
For the smell?
This
To block the smell?
right.
Well, if you've got a card, then why are you trying to block the smell?
But I just don't want to be right now. Smelling like
Well, how about don't keep it in your car at all?
that too.
That too.
This
So here's the thing, having that card doesn't mean you just get to do whatever you want and be high and drive a vehicle. You shouldn't have it in your vehicle. You should use it for the purposes and the amounts and the times that they prescribe you to use it. If you're not doing that, then it's going to be a violation of your probation. So part of your probation order is that you cannot have it in a car ever. It is to be at your house, probably needs to be locked up depending on who else you live with, and it is to be used how it's supposed to be used. If there's any issue with that, then it's going to be a violation of the probation, whether you have the card or not. You understand? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to their desk when they're ready to go over your paperwork.
This courtroom session featured 3 different defendants at very different stages of the criminal justice process. 2 young co-defendants appeared for their initial felony hearings after being charged with burglary, while another defendant received probation after pleading guilty to fleeing from police. Although the cases were unrelated, the judge delivered the same message to everyone in the courtroom. Second chances come with strict responsibilities, and failing to follow court orders can quickly lead back to jail or even prison. The hearing began with Jonty Harmon, an 18-year-old defendant making her first appearance after being charged with burglary of a habitation, a second-degree felony. Since she had already posted bond, the judge's first concern was whether she had hired an attorney. When Harmon explained that she was working but had not yet hired a lawyer, the judge decided to give her additional time. Rather than immediately appointing counsel, the judge reset the case for approximately 30 days and instructed Harmon to actively search for legal representation. The judge made it clear that simply waiting until the next court date would not be acceptable. If Harmon could not afford an attorney, she would need to meet with at least 3 different lawyers, learn about their payment plans, and return to court with the names of the attorneys she had contacted. The judge explained that every lawyer charges different fees, and the court wanted to see genuine effort before considering any alternative options. She also issued a serious warning. If Harmon ignored those instructions and returned without making any effort to hire legal counsel, the court could increase a bond and send her back to jail for failing to follow a direct court order. Moments later, Michaela Sylvester, Harmon's co-defendant, appeared before the court facing the exact same burglary charge. Because Sylvester's circumstances were nearly identical, the judge gave her the same instructions. She also received 30 days to hire an attorney or demonstrate that she had spoken with at least 3 lawyers if she remained unable to afford one. However, before allowing the 2 young women to leave, the judge noticed something important. She learned that Harmon and Sylvester had arrived at court together. Curious about their living situation, the judge asked several additional questions. Both women admitted they had recently moved out of an apartment complex known as Autumn Oaks and were now staying together in a motel. They also confirmed they were both only 18 years old. Those answers immediately raised concerns. The judge explained that, as a new condition of both bonds, neither defendant could return anywhere near the Autumn Oaks apartment complex where the alleged burglary occurred. They were also prohibited from contacting 2 specific individuals connected to the case, including Harmon's father and another family member who lived at the apartment complex. The judge stressed that these restrictions were designed to prevent additional conflict while the criminal cases remain pending. Normally, she explained, co-defendants are prohibited from communicating with one another while out on bond. In this situation, however, the judge recognized that the 2 young women depended upon one another financially and had nowhere else to live. Instead of immediately separating them, she chose to give them another opportunity, but she warned them that this decision came with conditions. If police were called to their motel, if arguments escalated, or if any additional problems occurred while they remained together, the court would immediately modify their bonds and prohibit them from having any contact with each other. The judge encouraged both young women to grow up, make better decisions, and understand that they were now facing serious felony charges, not minor teenage mistakes. She reminded them that their choices over the coming months would determine whether they remain free while awaiting trial. After receiving their new court dates, both defendants left the courtroom with strict bond conditions and a clear warning that future violations would not be tolerated. The hearing then shifted to a very different case involving Terrence Carrington, who had already pleaded guilty to evading arrest or detention using a motor vehicle. Unlike the previous defendants, Carrington had reached a plea agreement with prosecutors. After reviewing the pre-sentence investigation report, the judge formally accepted his guilty plea and found him guilty of the offense. Instead of immediately sending him to prison, however, the judge decided to follow the negotiated agreement. She deferred the proceedings and placed Carrington on 5 years of probation. The judge explained that this was an extraordinary opportunity. Because a conviction would remain deferred, Carrington was not yet a convicted felon. If he successfully completed every condition of probation, the criminal case would eventually be dismissed, allowing him to avoid a permanent felony.